Well, good morning, everyone. It's 9:02. I appreciate you all for coming out on a Saturday. I know we have to do this here. So I really appreciate it. Can you guys hear us online?
I can hear you.
Yep. I can hear.
I'm sorry, I think we lost audio.
Can you hear me?
I can hear you now.
Okay. Now you can hear me?
Yes, thank you.
All right, sorry about that. Yeah, so just remember that the go-to all the time is that your decision is made openly and your deliberations are done openly. Just a little recap. Next slide. And that openly is the norm, not the exception. I harp on that a lot because there are just times when you just don't remember that you have to be careful about what you're doing outside of the meeting, on breaks, all that kind of stuff. And so just be cautious and be aware of this, that you want to make those decisions, have the discussions and deliberations in the open meeting. The flip side of that, of course, is not everything applies to the open meeting, right? Today we're having a training and people are up here maybe from the same board. We have a quorum of a board present at the meeting today or the training. That's not going to be a violation of the open meeting law. Discussions with board members, discussions with constituents, those kinds of things, as long as you stay within the bounds of the law, are not going to be a violation of the open meeting law. Doesn't mean you can't discuss items that are of interest to you. It's just how you do it in terms of a quorum and the items that are coming before you as a board. Some of the critical definitions that we talk about in the open meeting law: deliberate, which is where you're discussing an item going towards a decision. It's not the actual vote, doesn't have to be the final action, anything like that. It's when you're discussing things that may lead to that decision. So that's where sometimes you see a problem where you're have an item on your agenda. You know, what kind of future agenda items do we want? And the board will get into a discussion and say, we want this item, we want this item, and suddenly there's discussion about that item. And that you can get in trouble for that because you're deliberating perhaps towards a decision on an item that's not on the agenda. Action, voting or decision, which is made by the board, the normal way you make a decision with a motion and a second, that's when you're making your decisions. Next. Just a quick checklist we do on the county side when we're deciding if we're in compliance with the open meeting law. Is the body subject to the open meeting law? We talk about this a little bit later, but generally all the boards in Lyon County are subject to the open meeting law if they're county boards, citizens advisory boards, planning commission, county commission, mosquito district, GID boards, all subject to the open meeting law. Is it a meeting? Has it been agendized? Is there going to be a quorum present? Are you discussing things that are within the purview of your board? Has it been properly noticed? We'll talk about that. Is the agenda properly put together and noticed? Will there be deliberation? Is there a provision for public comment? Are you taking action? All things that you think about when you're reviewing your requirements for the open meeting law. I touched on this, but the open meeting law covers a lot of boards in Nevada, and it's expanded rather than contracted in the last several years, covering committees and other things. And so generally the situation is that the boards that meet in Nevada and take action on behalf of the government are subject to the open meeting law. There are exceptions. The state legislature is an exception, oddly enough, that they adopt the laws that tell us we all have to do it openly. There's a few others. Judicial branch is generally exempt from it as well. But generally speaking, county boards are going to be subject to the open meeting law. Next. This is just the statute that says which boards are subject. I've already covered this pretty much. Any questions on what boards are covered by the open meeting law? Committees come up frequently. Less frequently now, I think, than they used to, but a lot of times the board gets together, maybe has a big item they want to work on. You only have one meeting a month, 2 meetings a month, and so you want to appoint a committee to do some of that legwork. That you can do that. We don't encourage that on the advisory boards, but you can do that. Just remember, if you do that, you don't get around the open meeting law. If you were asking that committee to get together, come up with some ideas and suggestions and come back to your board and say, hey, here's what we should do with this. That committee is going to be subject to the open meeting law. So it used to be a lot of times people would say, well, let's appoint a committee. It's a little bit simpler. You don't have to agendize the meetings. You don't have to have that formality, which is sometimes difficult for advisory boards or the planning commission or whatever. And so they would set up a committee would come back. You can't do that anymore to get around the open meeting law. You're still going to be subject to that. Some of the other things that come up, like agency staff, the county staff, county employees, usually not subject to the open meeting law. But anything dealing with the board directly is going to be subject to the open meeting. This just summarizes what I said. 2 persons appointed by the public body. Just a little additional clarification on the committee. And generally speaking, it's a broad rule, as you can see as you read this, see it on the slide. You're not going to appoint committees that generally aren't doing this, right? The only reason you want a committee is to help out the board and usually making recommendations. Quorum. That's one of the other terms that's important in the open meeting law. If you're not a quorum, technically you're not having a meeting, you're not subject to the open meeting law. And a quorum for most of the boards in Lyon County is a majority of the members. So if you have a 5-member board, 3 is a quorum. So if 3 of you meet, you need to be cognizant of the open meeting law. If it's an elected board, you need to have a majority of those elected officials vote in favor of an item to pass it. And so it's a little bit different. If it's not elected, the quorum is a majority, or you can pass an item with the majority of the quorum, if that makes sense. Any questions on the quorum issue?
Yeah, I have one on the quorum.
Okay,
Mandy Bernan, if there is a quorum is not present at a meeting and there's no for possible action items on the agenda, just for discussion items, can the like the Citizens Advisory Board still meet, or would you cancel the meeting?
everybody hear the question? Yeah, so our recommendation is always cancel the meeting. Because we really think that you need to have a quorum present. And you're going to be discussing things perhaps that are going to lead to a decision down the road, even if it's a non-action item. And so our recommendation is generally cancel the meeting. Is that required by the law? No, not necessarily. We just think that a quorum needs to be there to kind of oversee the meeting, know what's going on. So the recommendation is cancel the meeting. Do you have to? Not technically under the law. Did that answer your question?
Yes, thank you.
Excellent. Couple just general rules about your meetings, and most of the county facilities are fine for this. You have to have a facility that's adequate for your meeting. There are items that come before boards in Lyon County where we know the facility may not be adequate. If you have a contentious planning item or an item that's garnered a lot of public interest, you will fill your meeting room and people will be standing outside perhaps. That does happen. But generally speaking, where you hold your meetings is sufficient and complies with the requirements. You also have to be able to accommodate certain special needs and things like that. Teleconferencing and video conferencing, we're in the age where a lot of meetings are Zoom, and that if you do it that way, you have to be able to have a two-way communication. Okay. Question comes up sometimes, well, you know, some boards broadcast their meetings on YouTube, stuff like that. That's a different question. That is not, they're not conducting the meeting on YouTube. They're just broadcasting the meeting, which you can do. And that's just a different scenario. Next. This is a big issue that it's been around for a long time. And oftentimes people forget about it. And in today's day and age with social media and email, the way we communicate has changed so much that this can be a significant problem. And it's what they call the serial communication of board members, where you have an item on the agenda, you want to discuss it with a fellow board member. And so you call them up, or I guess anymore, you probably don't call them, but you email and you have a discussion about it. And then you say, well, I'm going to contact another board member. And pretty soon you've talked to 3-4 board members and you've shared information about what other board members have said. And then you're in a bad situation issue with the open meeting law. And this is the case, the seminal case in Nevada that kind of dealt with this issue. And it says that, you know, private briefings, whether they be with staff, whether they be with your fellow board members or whatever, can run afoul of the open meeting law if you do certain things. And so this is the case. Next slide. Generally talking about that, where you meet and in a series of meetings and you end up working towards a decision. Next slide. Talks about some of the things, emails, faxes. This case was actually a fax, I believe, and telephone calls, but next slide. And here's sort of the facts of the case, a little bit antiquated, but gives you a general idea of what happened. And so this was the Nevada Regents had an issue many years ago. And one of the regents made comments to the press criticizing decisions of the board. Other regents were understandably upset about that and made some comments. And the chairman of the board said, let's meet with the staff, the public information officer, and do a response. And then they shared that response out with all the other board members. Everybody okay to do it, sent it out. What do you guys think? Is that a violation of the open meeting law? Yeah. Right, they made a decision, decided to do it, no agenda, no anything else. Next slide. Next. And so they even though the press release didn't go out, there was such communication and discussion about it that it was still a violation of the open meeting law. Because people found out that they had discussed it, made some decisions, and ended up with a violation. Next slide. Next. So some of the things, there's an exception for attorney-client communications. The board can meet with their attorney to discuss legal issues. That never comes up with a citizen advisory board. And so you don't want to, that's really the only exception that exists to those kind of meetings where you're not agendized and where you can talk to people and share information. One of the issues that's a concern, I know, for the county and for board members is email, right? And it happens a lot. You're a board member, you get an email that has every board member on it. From maybe a citizen or an applicant or something like that. Here, here's some more information about my project. It comes to all the board members. You're used to doing emails, reply all, you respond to it. Any problem with that? Yeah, right, because you're communicating with your board, deliberating toward the decision, perhaps with email communication. Same on social media. I don't use a lot of social media, but I know Facebook is pretty common now. Some of the boards maybe even have Facebook pages, things like that. And so people post on Facebook. You see a lot of that stuff. You just need to be careful as a board member if you're on there commenting. Even a sort of a innocuous comment could run afoul of the open meeting law. So some of the things you need to think about. Any questions about serial communication? I think everybody's familiar with it now. It's been talked about long enough that people understand it, but it is a constant problem we deal with on the county commission, the planning commission, the advisory boards, all the boards really, where it comes up. You just need to be careful. No, Andrew gets a number of emails where all the board members are on it. He just needs to be careful how he responds to those. Okay. Methods for holding the meeting. As long as it's noticed in public, you can do it a number of ways. Generally speaking, we do in-person meetings. You can do telephone, you can do like Zoom meetings. And I know sometimes we have a combination of formats for the meetings. COVID-19 obviously changed how we do meetings and how we notice things in Nevada. There's other parts to that, of course, technology and other things have changed it as well. Many boards want Zoom. And so in 2021, they finally made that part of the law that you can hold your meetings remotely. The good part of that is that they changed the noticing requirements, which make those a little bit easier and allow Martha to do a lot of the posting that you were required to do previously. And so that is a good part of this. And also Zoom is convenient for a lot of people who, for whatever reason, maybe can't make the meeting, can't attend the meetings. Next. If it is an elected board, there has to be a physical location for the meeting still. And in Lyon County, we still encourage that there be physical locations for the meetings.
Question.
Yeah.
Elected board, like the Springs Advisory Board, we're appointed, not elected. Is that different? Like we don't have to, or?
I don't think you have to under the law, but we still, the county requires you to have physical location. Everybody hear that question? The question was, if you're not an elected board, can you have just a remote meeting without a physical location? The answer in the law is yes. In Lyon County, though, for the advisory boards and other boards, we require a physical location for the meeting. Again, we touched on briefly the requirements. If you do have Zoom, it has to be two-way communication. You have to be able to hear people that are on Zoom, and then also they have to be able to hear you. So next. I talked about this already a little bit, some of the issues that come up, and just to be aware of as board members, we all use the computers now, whether we like it or not. That's just the day and age we live in, and there's a lot of great information on that. But you have to be careful what you're doing on the computer, especially if you're at a meeting and stuff. We would encourage that you not be on your phones and stuff during meetings. I know that's hard sometimes, but it can just create an appearance of that there's a problem, right? Or what are you texting during a meeting? Who are you talking to? That needs to be public. Are you texting with other board members? We've seen that happen. That's just a bad thing to do because it can only get you in trouble. You just need to be careful about what you're doing in the meeting. The other thing sometimes that happens, and I know you can do research outside of the meeting. And that's probably a good idea on some things, do some internet research on a project or an item that's coming for you. Maybe you want some background information. You do need to be careful though, if you're doing that in a meeting with other board members, not knowing, because really, when you're in that public meeting, the public is entitled to know what you're thinking about and discussing at that meeting. So a lot of you have computers in the meetings and stuff, that's fine. But just be aware that if you're using information that's on that computer, you should let your fellow board members know that, and you should share that with the public. The exceptions to, we talked about these two to the open meeting law, social gatherings. Certainly, we want you going to community events and that kind of stuff. We don't want you to miss those because other board members are there. You just need to remember that appearance issue. If you're all huddled together, people say, what's going on over there? But certainly there's no requirement. Some people say, oh, I can't go to that meeting. You can use that as an excuse, but it's not a legal requirement. You can go to community events and things like that and meet with your fellow board members, training. And then we talked about the attorney section next. Okay, this posting the agenda. This comes up, and we've had some issues recently sometimes with boards. It's a pretty simple rule. It's set up now where Martha does a majority of that for you, the posting, if you're on an advisory board for all the boards really in the county, or most of the boards in the county. She's doing that. And if there's a principal location for the office, the agenda gets posted there. And then it gets posted on the internet, the website, and the state government information website. I forget, it's public meeting portal or something like that for the state. And so that's the primary places it gets posted. Used to be required that you had to post at 3 additional places in the jurisdiction of that board. And so you used to see at the library, the senior center agendas posted. You still see them there sometimes. We do want to encourage that people know about the meetings and things, but that's no longer a legal requirement. The legal requirement is that it's posted on the website, county website, and the state website. And if you have an office, it's posted at that principal office. What we do ask though is if whoever it is on your board, and even other board members, sometimes it is good to check to make sure that things got posted. There's a lot going on. Lots of meetings and things like that. So you just want to confirm that if you send something to be posted, maybe just take a quick check. Hey, was that posted? Are we all set? And just so you can avoid any problem with that. We haven't seen a lot of problems, but sometimes the information comes to the county manager's office in different ways. So, and there's just miscommunication, whatever the day of the meeting or whatever happens. And so it's posted late or something like that. We just want to try to catch that. And we do ask for the boards just to assist with that, to make sure that things are working smoothly. And that way you can coordinate and make sure that you avoid any issues with that. Any questions on the posting requirements? Okay. Pretty straightforward. We don't see many issues with that. Okay. The requirements for the agenda are still the same, right? The date and time that it's posted, the address, and I think this is a little bit different on what you have to do is you have to have documentation that it was posted. That's pretty easy these days because it's primarily posted on the internet. And so that's easy to track down. Next. Getting to the agenda topics. This is an important issue, and this is one of the issues that comes up most frequently with the boards during their meetings. And the general rule, the agenda must be clear and complete so that if you read the agenda, you know what's going to be discussed. Draft your agendas carefully to make sure that it spells out what the board wants to do, right? That's kind of where you want to be at the end. You want to be able to make that decision that the board wants to make. Sometimes we work an agenda item, have a big discussion, go to make a motion, read the agenda and say, whoops, that's not what the agenda says. Happens sometimes that, you know, no matter what board, county commission, planning commission advise. And if you get in that predicament, you can't make that decision. You are limited by that.
Yeah, pretty common that happened with a lot of board kind. Yeah.
Second thing, when you're doing your agenda, make sure that what the agenda says is something that is within the purview of your board. And so that's generally not an issue, but there are certain things where if you're going to take action, it's not really for an advisory board. It's not really for the planning commission. And so that's just kind of a general thing to think about when you're putting your agenda together. And then you don't want to just you can't make a general item. We're going to approve everything, but we do ask and encourage you to make your agenda items broad. If there's going to be a few things discussed on that item, include them all in that agenda item. Don't limit it, because then you'll limit what the board can discuss to do. Next. Here's just some examples that we pulled off some of the agendas and sort of some detailed wording on this, the planning example for a solar facility. And just kind of gives you the kind of detail that we'd like to see in agendas. And you can see when you read right up front, what are you asking the board to do that day? To approve a conditional use permit. The conditional use permit got the detail in there. Got the location, quite a few specifics. So anybody reading that agenda can tell what's going to happen at that meeting. Next one. Another example just of an agreement item that was on the agenda at one of the boards. And again, just tells what the board is going to do. So if you're in the public, you want to know what's on the agenda, you're going to know when you look at that the board is going to consider this joint use. Next. That's just another example on a recommendation. And this is something we see, and we had an issue this week. And as advisory boards, and a lot of times the planning commission, the role is a recommendation to the county commission or a recommendation to the planning commission. And we know as boards that what you're doing is you're approving that project if you're making a recommendation, or you're denying it. And that's going to be your recommendation, right? And that's typically how you do it. But if it is truly a recommendation, then it is probably better to have a motion that you recommend approval to the planning commission, the county commission, or you recommend denial to the planning commission or the county commission. And so just some technicality, but that's something to think about in your agenda. What is your role and how should that be put in the agenda? Yeah. Let me turn this.
You mentioned a motion to approve a request or make a recommendation to the county commissioners on the approval of a request. The opposite could happen, and someone could make a motion to deny approval of request. Is there a distinction between not approving a motion to approve a request and approving a motion to recommend denial of a request?
Did everybody hear that question on the Zoom? I think so. The question, just to summarize briefly, if I understand it right, is there a difference between not approving a request and denying a request? I kind of paraphrased that.
Right, making those
Yeah.
recommendations to
Yeah.
the county.
So, yeah, there is a difference, right? That a recommendation of approval, just not voting in favor of that means you don't approve or you don't deny it. It's not automatically deemed a denial necessarily. And so we always encourage you to try to reach a final decision so it's clear. Otherwise, that what you're talking about, if you say, for instance, you have a planning item come before the CAB and somebody makes a motion, I recommend approve. this project and it fails, 2 to 3 or something like that. And then there's no more action on that. When that comes to the planning commission, that's not going to be viewed as a denial or an approval because there was no firm action. The rules are a little bit different when you get to the final planning decisions by state law. That if you don't approve it within a certain number of days or deny it in a certain number of days, it's deemed approved. So there are some things that happen when it gets to the planning commission and county commission that are different. But generally speaking, just a no vote on some motion is not an action that's conclusive for the board. Did that answer your question?
Thank you very much.
Yes.
So I just had a question. So in that scenario you mentioned where the approval, or the recommendation for approval was not passed, but there's still concerns that the board would like to communicate to, they say, the planning commission. Is it acceptable to say, for someone to start a motion to generate a letter of transmittal with our concerns that we discussed, but neither approve nor deny?
Yeah. So my two issues with that, one, is that on the agenda? And probably it is. Generally, we're looking at the agenda and you can do something that is less than what's on the agenda. You can't do more, but you can do something that is less. So probably in a situation like that, expressing some concerns is that, something less than approving or denying. So you could do that. Again, though, you'd have to go through that same process with a motion and a second, and it would have to be agreement. Right? The board can't each individually make a list of pros and cons and send that off as board action. That's technically not going to be board action. Okay. You need official board action to forward those comments on. Does that make sense?
It does.
Do you guys want to add anything to that?
Yeah, I think so. So it's really helpful when boards actually send comments rather than just a recommendation of approval or denial. On a denial, for example, we need to know why you're recommending that item is being recommended for denial. That's really kind of the only way that the board can make a decision off of that. If we don't know, what issue there is in the community, something that, staff is missing. I'll touch a little bit more on this, a little more on this in my presentation in a few minutes, but if we don't know what's wrong with it, we can't work to try and either fix it or change our recommendation on our end. So really do encourage you to send that, and if it requires you to change the way that your agendas are worded a little bit, it doesn't hurt to say in your agenda item to forward a recommendation of approval or denial, or to forward comments, and then whatever it is. You can put all of that in your agenda item. There's no rule against that. That opens it up so that you have more options too. So you can certainly make that change.
Any follow-up questions?
And would you then say that the comments that would be related in that transmittal should be specifically voted on by the board?
Correct.
Okay.
So you're essentially approving that transmittal. That's what you're doing, right?
Yeah, and I think a lot of, so different boards do it differently, but some of the boards have changed the way they do their agenda items to where it says to approve a letter of transmittal, and then, to recommend approval, denial, or to forward comments to the Board of County Commissioners or the Planning Commission on blah, blah, blah. It gets kind of complicated, but it protects you the most. And that way you have the most options when you're discussing items. Like I said, it happens often. We had an item just on Thursday where it wasn't worded properly and the board couldn't take action, directed me to bring it back in 2 weeks. So with your type of items, you don't really have that option because of the state statutes on time limitations. So pretty much if we don't hear it when it's supposed to be heard, then we have to move forward without a recommendation. And we do find that information is valuable.
And yeah, just following up on that on the planning items, which I know the cabs deal with frequently. I think it would be the recommendation to have something, if there is a motion to approve, and there are reasons given why it was approved, to include that in the transmittal. Same with if it's denied, because that is helpful to staff and the planning commission and the county commission. And so you're just providing them with that additional information. You also know on the planning commission and county commission, anytime they approve or deny a planning application, they have to make certain findings and certain things have to happen, same with the denial. So you will often see that in the motion, discussion.
Okay, so to make that clean with comments, it'd be something along the lines of motion to forward a letter of recommendation for approval and include the comments of, and the person would list off comment 1, comment 2, comment 3, like that. And then that way, when it's voted on, the whole board has approved those lists that was just read out.
That's a good way to do it. I mean, if there was only a handful of comments and everyone seems to be in agreement on all of those comments, you don't have to necessarily list it out. You can just say and to approve sending comments to the board. I mean, something along those lines. But anytime that you're more specific in there, the better, I would say. Keeps you out of trouble. Oh, sorry.
Everything, all right, any other questions on that? Oh, answered your question. The other thing that when you think about the agenda and you're drafting your agenda, it just makes it easier for the board members to make that motion when the time comes. If the agendas kind of fit well to what you want to do, like you were just talking about, it just makes it a little bit easier to make a clean motion so everybody knows what you're voting on, because you can basically read off the agenda. And then you add in what you need to with the project and like we were talking about, the comments that you want to send on to that other board or whatever. It's just a little bit easier if you can go right off the agenda. Here's just an example of a case. I think it was out of Incline Village, maybe. They had an agenda that said District Board Policy 3.01, conduct meetings of the Board of Trustees, specific section 011, officers of the board. And on that agenda item, the board had a discussion and voted to reorganize the officers under the agenda item. What does everybody think the result is?
No good.
Yeah, right. You read that agenda item, and what do you think the board's gonna do with that? You can't really tell. I mean, unless you're a board member or you work for that entity, you're not gonna know what any of that stuff is. So that's kind of just an example of where, you want the public to be able to read your agenda in plain language and know what you're gonna do. Next slide. Another example of an agenda. This is the Lyon County Commission, the open meeting law violation from a few years back, where they used to have, during the legislative session, a lot of stuff going super fast. And the county wants to be able to weigh in on certain things, right? Pretty typical, but difficult to do with the open meeting law. Oftentimes there's legislation hearings that aren't agendized within that 3-day window. And it's really longer than that, right? It's probably for everybody to do their agendas, you figure a week at least by the time you get the draft, go back and forth. And so the county had an agenda item on the standing item on the legislature. We're going to discuss legislation, basically, and submit bill draft requests or such legislative issues. Pretty generic. And there was an open meeting law. We don't know what you're going to talk about. We can't prepare for the meeting. We can't make comments, anything like that. So in fact, that was deemed an open meeting law violation by the county. And so the county, as a result, has changed that practice where we actually list the bills that will be discussed. And if there's anything specific that the county manager or somebody else needs done, it will be included in that agenda item. So next, this is just some of the AG opinion comments. You need to specifically list what you're talking about. Blanket agenda items be problematic, and don't be there. Stand. I don't know why this slide, I have a few slides that this not even change, I'm not a power. But, yeah, this is just general items that are on your agenda. And sometimes these are so general that they're in your template or whatever, we don't think about it. And we have seen a few times where there's mistakes, wrong day, wrong date, wrong time, some of those basics. So just a reminder to check all that. You also have to have on your agenda, if it's gonna be an action item, for possible action. And there's some other requirements that are on all your templates for handicap access and those kind of special situations, if they request those. And then all of the agendas in Lyon County have 2 public comment periods, one at the beginning of the meeting and one at the end of the meeting. And it also has to include who you contact if you need additional information or supporting materials. I talked about this again. Possible action, most of your agendas state on there that you can take them out of order. That you can combine items or remove items at any time. And then if you have public comments, restrictions, those have to appear on the agenda. And I believe most of the agendas now are set up for that. But just be aware of that. If you think you have a big item coming up, you may want to put a time limitation on public comment if it's not already on your agenda. I believe most of the agendas now have like a 3 or 5 minute public comment limitation. Just for that instance where you have maybe too many people come to a meeting and you just don't want one person to take the whole time. Allow people to speak. We'll talk a little bit more about the public comment.
Steve,
Yeah,
a question about what is public comment. We've had some instances where someone is presenting a project and it might be somebody from the company that wants to do a project, maybe someone like Lisa from the planning department, and the public has questions of them. And I've generally viewed that as not being part of their public comment time, because they're more or less asking questions. They're not telling us what they think. Do you think that's appropriate to not have that count against a person's public comment time?
yeah. So the question is, if you have people making, asking questions, maybe making a comment during another public, or another person's presentation, does that count against the time limitation for public comment? The general rule to that is no. That it would not count, in my view, as against their time for that issue. But that's really at the discretion of the chair. And it really depends on how you run the meeting. Sometimes, for instance, the county commission, we do not allow people to interject during that process. They can come up on their public comment and ask their questions, but there's not a dialogue back and forth, because sometimes that can get a little unwieldy and can take a lot of time and is not productive. So we just caution you on how you conduct your meetings. That is good in some instances, certainly, to allow that, because it answers those questions during the presentation, which can be very helpful. But if you're on a complicated item, it can be problematic. So the chair should balance that out and figure out the best way to do that. Yeah.
The other thing I'd like to add on that too, though, is if you allow one person to ask questions, you can't then restrict it from somebody else, right? So you have to treat everybody equally. It opens a big door there. So generally, we, at the planning commission, as Steve mentioned, at the planning commission, at the board of county commission level, we don't do questions, and even if they ask it during a public comment period, typically we won't answer it because we don't want to get into that back and forth dialogue. At the citizen advisory board meetings, those are typically a little bit different, so you have that option, but you have to be very cautious that you're treating everybody the same. And as Steve mentioned, it can get out of hand really quick, so
And
be very careful.
yeah. And I think that the general practice in the meetings is you want to run that stuff through the chair. Right? So like, usually if somebody wants to ask a question, they ask it of the chair, who then would decide, yeah, I'll ask that person making the presentation. Does that make sense? Rather than just having a communication between 2 people that nobody on the board. Just so you have control over that. And that way you can say, that's not a question I'm gonna ask right now. It'll be explained later when staff comes up or whatever, right? So that you can kind of control that if that's the way you want to do it. But like Andrew said, we realize that sometimes the cabs are a little more informal, want to have more dialogue, things like that. Just be careful how you do that. And again, the chair can control that. Just because you do it on one agenda item does not mean you need to do it on the next.
I just have a general question. I've noticed the CAB, the public will ask questions to the board on an item that's not agenda. The board then gets into kind of a discussion of item. Should that be happening or is it not?
Everybody hear Lisa's question? Sometimes a board is in a meeting and the public comes up with public comment and starts asking questions. We'll get into this a little bit later in detail. And there's a discussion about that item amongst board members and the person. Anybody see a problem with that? Not on the agenda. Right? You can't do that. That is a big problem, and a way boards often get in trouble as they start talking about things that aren't on the agenda. It can happen two ways. Public comment is common. And then you can also have it on an agenda item where it kind of gets off into the weeds and pretty soon you're talking about something else. So two things you really need to be careful about. What I can tell you what happens at the planning commission and the county commission is that during public comment, generally speaking, other than a thank you, or we'll see what we can do, just some statement like that, board members do not generally respond or ask questions during public comment. The one exception would be a clarification, maybe, hey, can you clarify what you're talking about so that they can decide if it belongs on the agenda or whatever. But they don't have a dialogue or really a discussion about that. We'll put that on the agenda, ask that you come back and talk about it.
Quick question.
Yeah.
Is it appropriate for somebody during the public comment? Maybe they come to a meeting and they say, hey, I haven't seen this particular, there's a topic I'm interested in, but it's not on the agenda and I would like to request the board put it on a future agenda. Is that an appropriate thing? Like if they do that, that we say, yes, we can look into that and add it to the agenda, whatever the topic might be.
Yeah, so the question is, somebody comes in and says, this is an important item for me. I haven't seen it on your agenda. I'd like to have it on the agenda. That is a perfectly acceptable public comment, and the board can consider that. But the board can't have a discussion amongst yourself at that time and say, all right, do we want that on the agenda? What should it look like? Things like that, because then you're taking action on the item without it being on the agenda. So, right, it's fine to have people say that, and it's fine for the board generically to say, we will see about getting that on a future agenda. But going beyond that can get you in trouble.
Is there a standardized like form or method with which people can request things to be added to an agenda?
Yeah, I don't know the answer to that exactly, but I think there are forms that a lot of the boards have to request an agenda item. And so then the board can consider that. We also have a situation, I think, where on the agendas, there's a future agenda item. Again, it can be tricky. It's much easier when you have staff. Advisory boards can be tricky, but you can have an item, future agenda, and a board member can say, I'd like to have this on the agenda. Again, you can't discuss it and vote on it because it's not agenda what that item is. But you can have a section on your agenda for not action where a board member can request. Any questions on that? Did that answer your question?
Yes.
Yeah.
Thank you.
A follow-up on that agenda items topic. If the board is not allowed to discuss whether they should have it on the future agenda or not, how would it then be determined if the agenda request was going to end up on a future agenda?
Yeah, so generally, the way that works, I think, with what I've seen in the county is that's sort of a chairman call. Or, worst case scenario, it gets to the point where it's on the agenda. Should this item be on the agenda? And so you've agendized that and you have a discussion about it. So that would be the two ways. I mean, I know that's messy, but I think that's the way that complies with the law. One, you delegate that to the chairman. They have generally the final say. Does that go on the agenda? Or you you have you say, we can't decide, or I don't want to decide, and let's put it on the agenda, and you have a discussion, should the board consider this at a future agenda? And then people know what you're talking about. So I know that's cumbersome, especially when you meet once a month, but I think that is what the open meeting law requires. And did you want to add something on that, Andrew?
No, that's exactly what I was saying.
Yeah. Yeah, Dan, I know a lot of you've been chairs of these boards and stuff. It's not easy. The open meeting law definitely doesn't speed things up all the time. So that's just the reality though. Some of the problem areas we see on agendas and things that we want you to think about on the boards is, workshops. A lot of times you want to have a workshop and you want to have a discussion about a general item. We're trying to improve the park in Silver Springs or whatever. And so you do a workshop on Penny Park and it's not listed for possible action. You have some public input, a lot of good ideas. And then you come to the end of it and it's like, okay, what do we do now? A lot of times they say, well, we want to direct a recommendation to the, to the buildings and grounds department to make this change to the whatever sprinkler system or whatever, and it fits in your agenda. Can you do that? No. Because a lot of times people think we're just gonna have a workshop and then they don't think that at the end of that workshop, a lot of times you want to take action. Just because it's a workshop doesn't mean you shouldn't put forward possible action, right? You're there to make decisions. And if that's what you want to do, make sure it's a forward possible action. Yes.
In a situation where a board does have staff, say the library committee, who's in charge of deciding what goes on the agenda? Is it the chair or the staff that makes the final decision about what agenda items go on?
Depends on the board and it depends on the circumstance. Generally speaking, I can give you the example of the county commission. The county manager is ultimately the person that decides what goes on that agenda. And so I think that's typically what happens. But there is a general policy that people can request that things be put on the agenda. So if they're not included, there needs to be a reason, especially if that's a board member request. But there are occasions I know with the planning commission and the county commission and CABS where board members request items, they do not go on the agenda for some legitimate reason. But there should be a legitimate reason. We want board members certainly and the public to have items that are important put on the agendas discussed, right? At the same time, you can't have everything on it, right? There's a lot of things to discuss. You don't make that much. So it can't be that anything goes. It has to be kind of tailored. You need to have those gatekeeper functions. Reports, same thing as workshops. You get a report from county staff. Lisa comes in, gives you a report on planning or whatever. If you want to take any action on that, it gets a little tricky because you need to state what that action is going to be. But just be aware of that. If it's a specific project or something, you may want to have an action. Presentations, generally not possible action, but again, think about who's doing the presentation, why is it there, what is we're wanting to do. Updates, generally with generic stuff like that, you're not going to be able to take any action, have any real discussion. Future agenda items we talked about, and but just always have in mind, if you want to take action, don't forget to include that piece. Otherwise, you'll be out a month waiting for it to be re-agendized so you can vote on something that happened. Okay. Next. Basic meeting rules. Again, stick to the agenda. This is a problem we see from time to time that it morphs into something else. The chair or another board member needs to bring it back to the agenda item. Then we talked about comments and questions and things through the chair. Just a better practice. We understand that there are items that lend themselves to more of a group discussion. Again, you want as a chair kind of at least oversee that coordinating. And the chair can always put that to a stop. Administrative action, not something we see very often. But it's a special section that requires notice to a person. If you're going to take administrative action, discussing things like property, business license. And the reason that's important is that if you're going to do that, you have to give that person individual notice that you're gonna be talking about that. Right? You can't take action against somebody that's negatively going to affect their business license or their property without letting them know and giving them a chance to work. So this does come up from time to time. We need to be careful about like code enforcement issues. We have seen that on some of the boards. Huge issue in Lyon County. We all want to work on cleaning up some of these problem properties in our communities and things like that. But if you're going to be discussing a certain person and what they're doing or not doing on their property, you need to back off a little bit and maybe reach out to the county manager's office or the DA's office. What can we do? What's allowed? I know there are a lot of generic discussions about code enforcement issues, development issues, things like that. And those are appropriate as long as you're not pinpointing some particular individual or some particular property, right? And so that's just something to be cautious about next. This just goes into a little more detail. And it's dealing with that individual property owner or business license owner, those kinds of things. And this is, again, talks about what is action against the person for administrative action. And it is like when a person makes an application for a planning, a conditional use permit or something, they're coming forward asking you to make that decision. So they're aware of it, they can be there, they know that you're gonna talk about. And you can talk about what their project is, other things they've done, that kind of thing. That's a little bit different, but what we see occasionally is on the general discussion, we're gonna start talking about this property and that property. And you just need to be cautious about that without notice to that person. Public participation, we do it pretty much the same way in all the boards in the county. You have a public comment at the beginning of the agenda, public comment at the end. And then we encourage you to allow public comment after each agenda item before the action is taken. And that's the standard practice we use. There's no action under the public comments at the beginning and the end. We've talked about that and what you should or shouldn't do during that public comment section. We do encourage you also to allow public comment on the individual items. We talked about that a little bit. And then that's before you vote. So a lot of times they'll have the public comment, then a motion, or you have a motion, then the public comment. You can do it either way, but we do ask that you have public comment on each agenda item. If the person asks that their comments be included in the minutes, they should be included in the minutes. People can email in comments. Usually you have a system set up for that. If you don't, that should be clearly stated, but you want to have what that means for people to get comments to the board. And next. People can request the agendas. If they request a copy of the agenda, that's a continuing request for 6 months. And that agenda has to be provided when the agenda has to be posted. A little bit confusing, but at the same time. So if you have to post your agenda 3 days prior to the meeting, you have to provide that notice 3 days prior. It has to be the final agenda. You can't amend the agenda after that deadline. Supporting materials. A lot of times people want the backup that goes with your agenda. Nowadays, it's a little bit easier because that's usually electronic with the agenda, not always. And but if they request that and you do provide it, you have to provide it at the same time you provide the agenda. And the other problematic thing we see on a lot of these boards, any materials, sometimes things come in after you've posted your agenda, right? Like you get a notice or something from the planning department, you get a notice from the public, you get some other document that you want to put that in the packet. That's fine, you can do that. You can present it at the board meeting even. That's often the way we recommend you do it. But if you provide that to the board members, your fellow board members or whatever else, you have to provide it at the same time to anybody that's requested the copy of the backup. Okay. So you need to be careful about additional information that comes after that initial agenda packet is created. Can be a little bit cumbersome, but something you need to be aware of. Again, kind of gets into that email thing. Hey, I received this from the applicant. Forward it to all your board members. Make sure you have somebody that's forwarding that on to people that requested it too. And then it's going to be arranged and be posted. Good.
But, sorry.
Yeah.
On that last one there, that last comment, this is not a continuing request, so it's by item though, right?
No, I mean, technically, I guess somebody could request for one item. Usually what you get is a request, I want the supporting materials.
Right.
And, so that request, they can't say I want supporting materials. for next week. You could honor that request, but you're not legally on. Okay. Yes.
If someone from the public comes to the meeting with prepared remarks that they say and ask to have included in the minutes, how do you include those in the minutes if they say they hand in their statement and ask to have it included?
Yeah, so the way we would usually do that is they would be an attachment to the minutes,
Attachment to the minutes that would be,
approved as subsequent.
Okay.
Right. So that's happened sometimes. They want their minutes, their item reflected in the minutes. Two ways you can do it. You can either incorporate those entirely in the minutes, which we don't recommend, or you can just attach it and reference the minutes that so-and-so spoke at the meeting, asked that their comments be included. Any other questions on that? We'll talk a little bit about the minutes too. There is a requirement if you have a meeting that you have to have a copy of the agenda and the packet at the meeting. So that is still a requirement. If you go to the planning commission, you'll see the table that have a packet there. So if somebody wants to look at it, they can. The Attorney General has now said you can make that available electronically too. Unfortunately, you can't require the person to use their own device to view it. So that's not it does help, I guess, in some situations, but most of us, including the county commission, do not have like a standalone computer where somebody may get to that point in the future. Because there are days, I'm sure, where Martha would prefer not to make a copy of the whole packet or several, as often happens. But we haven't got to that point yet, but that is something that may be coming soon, but an electronic copy is suitable if they can view it other than from their own device.
So I have a question on the attachments. If you link them in your agenda so that they can open up that link, it would be on their personal device. Would that meet the requirements if they can open up a link in the agenda to view the attachments?
No, my understanding is you still need to have a copy present. That you can't rely on them to use their own device to open it up.
Okay, so if it's, because some of these presentations are like 100 pages long. So we're supposed to be printing those up?
Yeah, technically, you're supposed to have a copy, one copy available at the meeting.
Okay, thanks.
So we talked about the minutes, and minutes are really important. A lot of times I know there can be a hassle, but they can be very helpful, especially if you get down the road and want to remember what was discussed. I know we all knew that as board members. We say, well, didn't we discuss this or something similar a couple months ago? You want to look back at the minutes. Sometimes you look at the minutes and say, those don't tell me anything. So you kind of want to, your minutes you do want to have some information in there so you can tell what happened and other public can too. So usually it states the agenda item, the substance, the motion, the second, who voted for and against. And if they request it, the names and that kind of stuff, I think we usually recommend that's included. Obviously, if all your items are 5-0 or whatever, you don't have to list that in every item because you'll have all the board members that were there listed at the top. And that's public comment, especially if the person requested to be in there. But generally speaking, you want to include a little bit, at least the names of the people that are making public comment and the general crux of their comments. A lot of times you'll have people get up and they'll talk, basically make the same comment in favor of a particular item or against it. You don't have to reiterate all those, but list those out and say, you know, these three people spoke in favor of their general consensus. And then if a board member requests something in the minutes, that should be. Just some general rules on when the minutes must be available 30 days after the meeting. We know that a lot of times your timing of your meetings does not coincide with that. So the minutes are final, but generally they're still available, and then they'll be approved at the subsequent meeting. They are let's see. Recordings maintained for 3 years, minutes retained for 5 years. Just a little more information on what's required in the minutes. And again, like your agenda, you know, you want to periodically look at your minutes. Are these serving on purposes? Want your board to have a good record. That it is nice. You have to research something, go back. Or historically, they have some minutes just well. So they can be. Public comment. Again, we've talked a lot about this. I think everybody's aware of it. You can limit public like time and how many times they can speak, that sort of thing, but you can't limit what they're going to say. So sometimes that becomes an issue. People have things to say that you don't want to hear. People have things to say that have nothing to do with your board. From time to time, people just want to talk. Unfortunately, as a board member, you have to listen to that. And sometimes it's pointed comments at the board. Certainly, they're not allowed to threaten or do anything, you know, foul language, stuff like that. You can shut down. But generally, criticisms against whatever, that stuff's all legitimate. You can't tell people to stop talking. You don't want to hear what they have to say. Yeah.
Hey, Steve, it's Nicole. I got a quick question for you, if it's all right.
Yeah.
Sorry, I was trying to figure out how to unmute my thing here. So for minutes, I was under the impression that minutes are permanent.
Minutes for the county commission, I believe, are permanent.
Oh, okay. Gotcha. Sorry, I wanted to make sure because I was like, oh gosh, that changes everything.
Yeah, there are boards where the minutes are permanent, but the open meeting law requirement is that they be retained.
Gotcha. Right on. Thank you.
Yes.
So I had a question on what you mentioned with the First Amendment, and if they get, you have to listen to them, but if they get, you mentioned like if they have foul language or stuff that you can interject or stop them. I'm just curious about about that, like the legalities of that. First Amendment basically means you can say what you want with the limitations of like, you can't threaten people or, you know, threaten harm or things like that.
Yeah.
When it comes to things like say foul language or, like an example that's been in the media and stuff where people will go to like school board meetings and they'll read from the text of books that are in school libraries that are inappropriate, and the board doesn't want to hear them reading these inappropriate passages from the books, which are very explicit, for example. Like explain that aspect to me. Like how can they say don't say that, but you have the right to the freedom of speech, or how is that not your freedom of speech?
If I gave the impression that any kind of foul language or anything offensive is not allowed, that's not what I meant to say. Certainly, if somebody comes up and reads something that you view as inappropriate or whatever, that's going to be free speech, right? If they're reading a book, they're reading a statement. What I'm saying is somebody that gets up there and is just using profanity towards the board members, the public, and not saying anything.
So
I mean, that affects the decorum of the meeting. That's not legitimate public comment. But if somebody gets up there and says, you know, they want to read something about sexual material in the library or some legislation or whatever it is that includes sexually explicit things or profanity, law that prohibits some kind of profanity, whatever, they read that stuff, that's certainly allowed at public comment. And
So-
it is legitimate First Amendment.
Right, on the profanity though, like, let's say that's just part of the way that they speak, is they use profanity. They're not necessarily addressing like to the board, like cussing at the board, but they just have a foul mouth as they speak.
Yeah.
That's
the
different.
difference.
Okay.
That's, I mean, that's different, and that, we
Okay.
do see that from time to time, and yeah. Generally, you're gonna let that person finish their presentation, but there are limits to that, right? And I think, not that we're trying to control what they say, but yeah, certainly if that's how somebody talks and they use that language in just their normal vernacular. Yeah, you're gonna let them make their statement.
Right, because they're not addressing it at somebody in a derogatory manner.
Yeah,
Okay.
right.
Yeah.
Yeah, we're not trying to interfere with what people want to say
Right.
and how they say it. We're not interfering with their ability to discuss or think something they think is important that involves obscenity or whatever else, and that's fine. What we're trying to avoid is the hate speech and the speech that is threatening or that is just disruptive. They can disrupt, I guess, a little bit, but you can't just get up there and go on a expletive tirade and have the board sit there and listen. And it's gotta be public. And I don't think we see that a lot, just something to be aware of. And again, we talked about that meaningful public comment. It doesn't really require it to be meaningful. But there are limitations. Time limits come up a lot, a lot of the boards have like a 3 or 5 minute time limit, and then sometimes person's talking, they're almost to the end. Timer goes off. You don't have to make them stop. You can let them finish. You can ask them to finish their comments. You can also shut them down and say, sorry, you're out of time. That's kind of a discretionary thing. Certainly you want to conduct your meetings in a manner that allows you to get the information you need to make a decision. And that's fair to the public. But you need to balance that against time, kind of saying, and that kind of stuff. That again is sort of discretion. Next. Okay, so again, talking about violations, just don't commit to doing anything outside of the open meeting. No, don't tell people you can tell, we all know that as board members, our mind is often made up before we get there. Nothing against that. We do want you to listen to things and hear things, but we're all predisposed. We all have opinions. But you shouldn't be making commitments to your fellow board members outside the meeting and doing things like that. So that's where you can get in trouble. Next. Sometimes with the advisory boards especially, but all boards can be, well, we're just Lyon County, a little more informal. The open meeting law doesn't apply to us. Unfortunately, that is not the rule. We had a board several years ago that had a violation every month for, I don't know. And it was always, we can't figure out the rules. We can't do this. That's not an exception. If you have questions, don't hesitate to contact county manager's office, the DA's office will help walk you through it. There's a lot of people that served on these boards for years, have a lot of expertise and can answer those questions. Reach out to them, reach out to your fellow board members, but strict compliance, no matter if you're an advisory board or the county commission or the Nevada Regents, you have to strictly comply to it. Civil penalties, criminal penalties, those are all things that can happen. We don't see that very often. Again, if you're acting in good faith and trying to resolve problems, you're not going to have an issue. Corrective action, this is something we always encourage you to think about. If you find out that you violated the open meeting law, try to fix it. Try to fix it during that meeting. You can bring up the agenda item again, say, hey, we made this mistake. We discussed, the 3 board members discussed it in the hallway on the break. We just want to bring that up, want to open it back up, public comment, anything else, just bring it up to attention. And usually that will solve the problem. So we don't just sweep it under the rug. If you're aware of a problem, bring it up. If you're aware of a problem after the meeting, you still should bring it up. You can bring it up to the county manager's office or to the DA's office, and we'll try to walk you through a solution, maybe even put it on the next agenda. We have had that. Next. This is just an example in Douglas County. of what we're talking about. There was a planning item. Some of the board members talked out in the hall on a break. When somebody in the public heard them talking, they came back in, they brought it up. Next slide. Next. And so what they did is they ended up bringing up the item, and it was the Attorney General said that they cured that violation by informing the public that there was this discussion, that they allowed comment on that, and then they, the Attorney General said there was no violation. So again, we want you to try to, if you are aware of a violation, try to fix it. Sometimes you can't, but we don't want you to just say, oh, we're messed up, can't do anything about it. We always want to try to fix it. Again, if you are going to cure an item, like you have an open meeting law violation, we need to put it on the next month's agenda. That's not a ratification or just an affirmation of what you did before. It has to be discussed, opened up, and allow the public to comment on it again. So it's actually not just a circumvention of that. What's the consequences of a violation? Your action void, and then there's some other things that can happen. Next slide. This is the Washington County School District case several years ago. Some of you may remember this. Not very often the board members get fined, but in this was the case where the board members were each fined $500. They terminated the superintendent outside of a public meeting, no agenda. It's a pretty egregious violation. Again, just to kind of remind you that try to comply with the law. You are required to comply with it, so there can be consequences. Okay. Sometimes if you have a violation, we have seen this on occasion, you have to post it on your agenda. It has to be an agenda item that's discussed, and the public gets to see what the Attorney General said about the violation. Some of the resources that we asked you to look at if you have questions. Certainly the Attorney General manual online is very helpful. Has a lot of good information. You go to their website. They also have the Attorney General opinions on there by year. So if you have a specific issue, you can look for that and find out what the Attorney General has to say about various issues. Sometimes basically everything you have come up to your board has probably happened to other boards. So you can usually find some good information in that. So that's all I have. Any questions? Take a short break and then start.
Go ahead and take a break until 5 minute breaks. Back.
Have a great day.
I don't know about anyone else on Zoom, but I can't hear anything.
Is that better?
Yes, thank you.
Oh, I apologize.
That's okay. I don't
didn't-
think it came through from when you guys turned the recording back on.
Okay,
I'm sorry.
all right, no worries. Just, I was just kind of going over, what we're gonna talk about, for this presentation. I'm gonna try and skip over as much as I can, because Steve already covered it in the open meeting laws, presentation. So just recapping that open meeting law is responsibility of the board members, to comply with. So everyone needs to be doing that. Next slide, please. So we're gonna talk a little bit about agendas. So the agenda serves as the public's notice for the meeting. That's why it's so important. Stan, Steve talked a bit about some of the requirements, but it has to have the time, place, and location of the meeting, where the agenda has been posted, the CAB email name and contact information for the person that is the contact for that board. Clear and complete statement of all topics to be discussed and considered. So Steve talked about agenda items. The public has to be able to know what you're going to be talking about based on that agenda. If it's not clear, if you don't know as a board member what the agenda item is going to be about, then it's probably not clear to the public either. So we need to be making sure that those items are worded such. Something that we've changed, the Board of County Commissioners has directed me to review all the Citizen Advisory Board agendas before they get posted. Which is why we've had to add a little bit of time that you have to send that to me before the posting date. I think it's 5 days is what we're requesting, just to make sure that we have time to take a look at that, make any changes that need to happen. So that's something that's a little bit different than what we have done in the past. We started implementing that this last year. It's been working pretty good. I think I've only had one where the agenda got to me the morning of the meeting, or the morning that it had to be posted. I was in a meeting and I couldn't get to it in time, so they had to cancel that meeting. But just something to, I just so that everyone knows that I do review those agenda items. Make sure that I understand kind of what you're going to be talking about and how that's worded. In general, if there's nothing wrong with it as far as as long as it's clear, I'm not going to make any changes, but we do encourage you to take a look at how that's worded so that you can take all the actions that you want. I'm not going to go in there and say, approve, deny, or, send a letter, transmittal or something. If it meets the requirements, and that's how the board wants it, then that's how I will leave it.
Andrew,
Yes, sir.
should we, when we forward the agenda to Martha, should we also include you directly on that email so you get it a little sooner, or?
So I actually already am. When you send it to county clerks, I get all of those emails, so you don't have to do that. One thing I do want to caution everyone, I know Steve touched on this a little bit, is oftentimes when somebody will send me, when the secretary will send me an agenda or send that group an agenda, they will copy all of the other board members on that email. Don't do that, because that could be an open meeting law. So just send it to us. Don't send it to everyone. That's really important. And oftentimes you won't see me respond back just for that reason. So I will just respond back to the clerks and let them know that it's okay to post, but getting that from me. Does that answer your question?
Yeah, it brings up another one though.
Okay.
In that I have, in addition to sending it to the county clerks on a different email, sent the agenda to the board members at the same day, at the same time, not on the same email. Should board members not see the agenda until it comes out publicly?
Yeah, typically my recommendation would be to wait on that until it gets posted and comes out publicly. The reason is you could inadvertently create a situation where somebody replies all, and now you've created an open meeting law violation, right? Or somebody says innocently, right? Oh, well, what about this agenda item? but now you've discussed it, so as a group, so that's why I would recommend that you don't. Our board members at the county commission level don't see the agenda until it gets posted. The only one that sees it is the board chair when we do our every other week agenda review meeting. But we don't have a quorum in that meeting. It's literally one board member. All right, moving on, you have to have a statement on there that informs the public that items may be taken out of order, combined for consideration or delayed and removed at any time. There's 2 public comment periods, one at the beginning and one at the end. And then, as Steve mentioned, if it's something that you're going to take action on, it has to say for possible action. Now there's items that are not going to be for possible action, that are just presentations, that are informational only. The board's not going to deliberate on those, and you can put for discussion and presentation only. But if the board is planning on taking any kind of action on that, you always want to put for possible action on that agenda. It was brought up, some of the comments, if you can discuss items, whether or not they should be on an agenda or something based on public comment. You really can't be doing that. Steve mentioned our recommendation really is to have the board chair either make that determination as to whether it's an appropriate item, or to bring back another item to discuss whether it's an appropriate item. And if anybody ever has any questions, you can always reach out to myself or Martha or Steve, and we could talk. So the agenda must follow this order of business at the beginning of it. So you call to order, you provide the notifications that you're required to provide at the beginning. Agendas may be taken out of order. The public body may combine 2 or more. Any restrictions on public comments. Then you move to the roll call, public participation. That's your first public participation section. Review and adoption of the agenda, body of the meeting items, and then your public participation and adjournment. For adjournment, I do get this question often. You don't have to have a motion to adjourn. You can just adjourn the meeting. So it doesn't have to be a motion and a vote. So once your agenda has been drafted, then the chair and secretary should review that agenda. So that's where you can send it, but as long as you're not sending it to multiple, but you can review it and make sure that there's nothing missing that's supposed to be on there. You want to take a look at reviewing your wording to make sure that the agenda item says what action you're going to take or would like to take, or possible actions, and then you can email the chair to, excuse me, I already covered that. Then you can email it to us and we'll review it before it gets posted. Next slide. So covered this a little bit, but email the county clerk's email 5 days prior to the posting time. That'll give us, so that's 8 days before your meeting. 8 working days before your meeting. That gives us enough time to get it reviewed and get it posted. We've been pretty quick about, or I've been pretty quick about trying to get them reviewed and posted. So we try and get it done as soon as possible. Martha will post it to the websites and respond to let you know that it's been posted. We will retain all the required documentation that we have to do as a part of that. We also require that your agenda be saved in your Google Drive so that all that information is available. And then like I said, we keep all that. We always post the agendas on the cork board out in the hall at the county offices. That's where we have to post it. It does. Steve touched on this a little bit. It used to be where you had to post it at each agenda meeting location. We don't have to do that anymore, but it does have to be posted in the county office. So,
Quick question on that. Cancellations, like if you're canceling.
yes.
I don't know if you're gonna cover it in the future.
I do have a slide for it.
Okay, I can,
All right. All right.
I just wasn't sure if that was gonna come.
Nope, it will. So drafting your meeting minutes, we always recommend that you put together a template before your meeting. It makes it a little bit easier for you as you're going through and keeping your meeting minutes. So you already know what agenda items are going to be talked about, right? And so you can kind of put together the skeleton of it and then just fill in what was discussed, how the vote went and everything. It makes it a lot easier. You can fill in the motions, all that stuff. Ahead of, not ahead of time, but you can fill in the motions at the meeting or right afterwards so that it's still fresh in your mind. But if you prepare your template ahead of time, then it will be a lot easier for you. So you can literally just copy and paste that directly out of your agenda. It makes it super easy. The meeting minutes must include the date, time, and address of the meeting, members in attendance, whether they were there in person or by means of electronic communication. So for those boards that have Zoom capabilities, not all of you do, but make sure that if you have a board member that's attending via Zoom, that's noted in your meeting minutes. And if those are, if there are absences, you have to know whether or not they were excused or not in the meeting minutes. And then state the substance of all matters proposed, discussed, or decided. The meeting minutes really should reflect the issues that the board members have brought up. Doesn't have to be word for word by any means, but just say on a planning item, Commissioner XYZ or board member XYZ had concerns about roads. Might want to put some more specific information in there, like what specific roads they had or something like that. But it should be a record so that we can go back and look and say, okay, get a pretty good idea of what was discussed at that meeting. Believe it or not, the CAB meeting minutes get included as a part of the record when we have planning items. So if there's a dispute on a planning item and it goes to a court case, those CAB meeting minutes are part of that record that gets reviewed and are used as a part of that case. So we have to be able to tell kind of what was said without having actually attended the meeting. You also have to reflect each board member's vote and then remarks by the public. It's a good idea to include some of that as well. Here's just kind of a template of what the meeting minutes should look like. So covered a lot of it, but you can see it's got roll call, somebody present via Zoom, you've got somebody absent, and then it kind of goes through public comment. Somebody made a public comment. It doesn't have to be, like I said, word for word, but it just should give a flavor for what was discussed. So letters of transmittal, these are letters of transmittal from the board. The bylaws cover the letters of transmittal, so this does not necessarily have to be approved by your board to submit this if it's like a public comment. So this example, you're just letting the Board of Commissioners know that there was public participation, and Cindy Smith reported there's a lot of traffic at Wilson Canyon and is concerned with public safety. That's not the board's opinion, right? That is this specific person provided that public comment, so you don't need to vote on that on whether or not to submit it. Obviously, you don't necessarily have to submit a letter of approval for every piece of public comment that you receive, and it's probably better that the CAB try and address it at their next meeting first before submitting a letter of transmittal, so that you can get some more information on the item. But this is an example of a letter of transmittal for public comment. And then this is a letter of transmittal that would come from the board on a zoning map amendment request. And so you can see, it says what the vote was, it talks about the advisory board public, or public concerns, and then who submitted it. As I said before, it's really important for us, if we just get a letter of transmittal that says we recommend approval or we recommend denial, there's no other information. It's not very helpful for staff or for the Board of County Commissioners or the Planning Commission, because they don't know why you recommended denial, right, or approval. There may be legitimate reasons that have been brought up, that staff missed in their staff report, or that the board is unaware of because they don't necessarily live in this community, right? That they should be aware of when they're discussing specific items. So I'll talk a little bit more about that in the planning section, but I really want to make sure and stress that there should be more information in a letter of transmittal other than just we recommend approval or we recommend. It should have kind of a statement as to why, what the concerns were. Yes, sir.
So, we have our meetings on Wednesday and then the commissioners meet on Thursday. So, get our letter of transmittal out same night as our meeting. How does that get to the commissioners for the next morning so they can see what our input is?
Sure. So typically with planning items, so the question for everyone on Zoom was how specific to the Stagecoach Advisory Board. Their meeting is on Wednesday night. The Board of County Commissioners meets Thursday. And so how does the letter of transmittal get to the Board of County Commissioners before, so that they can see it for the meeting? So typically for a planning item, for example, right, now those are the ones that we have a time frame on in state statute. You're going to be reviewing those a month ahead of the Board of County Commissioners. So there's plenty of time. It's not the next meeting that they're going to be taking a look at it. Now, if it's something that's other than a planning item, that's where the board chair may have to attend the meeting. We do have a section on our agendas for advisory board reports. It doesn't have to be the board chair, it could be the vice chair or the secretary too. But if it's an item that came up and the board is going to be talking about it at their next meeting, that may be where where that has to happen. So, all right.
I have a follow-up to that question. This
Sure.
is Stagecoach Advisory Board. So if we do get a lot of planning ones, well, not a lot, the few we get, and the next day is a BOCC meeting. So you're saying if that occurs, we should bring that up during the advisory board reports or during the actual agenda item on the BOCC or Planning Commission agenda?
It could be either or, really. I mean, I would kind of recommend the advisory board report happens before the agenda item typically, so it can be either way. And generally, we try to get that letter of transmittal. If we do get it that same day, we will try and get it in front of the board. But typically with planning items, like I said, they usually hit the citizen advisory board a month before. And if that's not happening, I guess we should talk about that a little bit and your timing on things, but usually we're sending that out early. Nicole, I see you have your hand raised.
Yeah, hey, so just on the clerking end, Nicole Wagner, Deputy Clerk, not for the record, but I guess just so everyone knows. What is the typical protocol or direction for boards to get their minutes and agendas in? I don't know if this is a little late to ask this, but I do notice on our end, sometimes we receive minutes way after the fact. I think NRS states that it has to be 30 days after adjournment. And there's recently we've gotten minutes where it's like 6 months after the fact. So is there any direction or typical time frame for minutes and agendas to be coming our way for posting, just to make sure we're following open meeting law?
Yeah, so as Nicole mentioned, the boards are supposed to have their meeting minutes within 30 days of the meeting. Now, sometimes how that works out is your next meeting doesn't happen before that 30-day time frame. So, and they have to be approved. So you still need to approve it before we can get those posted. And Steve, I don't know if there's any requirements if they cancel a meeting with that 30 days. They still have to be approved by the board before they can be posted. So is it within 30 days of approval, or?
Yeah, they have to be approved within 45 days or the next meeting of the whichever's.
And then if I may, is it that the minutes can be posted, but they need to be identified that they're still in draft or they're still pending approval, or they cannot be posted until they've been approved?
We have yet to be posted in draft.
Okay.
But they're
Gotcha.
Yeah. Google and the.
Oh, yeah. So if you, so what I would say on that, then, a really good question, is if for whatever reason your meeting is going to get canceled and you're not going to be able to approve it within that 45 days, then still send it to us, and we'll go ahead and post it as a draft so that we're still complying with that law. And then we will update it once they get approved by your board. Because that does happen, especially with some of the smaller communities. I know that your meetings get canceled from time to time. It just happens. There's nothing to talk about. All right. So canceling a meeting, we have to post a notice that the meeting has been canceled. So if you do plan on canceling one, you still need to send us basically an agenda, but it says this meeting is canceled. So it's a shortened version. It still has the name of the board, the date, date and time, location, building and address and agenda, but then it just says meeting is canceled, and then the regularly scheduled meeting has canceled, and our next meeting will be such and such. So it's really important. If you go on our website and you look and see, you can see where we've posted these notices for boards when they do cancel. We also post this on the cork board out in front of our office, so that folks can see. So this is covering canceling a meeting after it has started. So sometimes you get to the meeting and you find out that you don't have a quorum, or I know, like in the case of the Dayton cab, I got there and there was a problem with IT. They had updated the computer and the Zoom wasn't working. So we had to cancel the meeting. So in that instance, what you would do is start the meeting. You would do your call to order and your roll call to determine if there's a quorum. And then if there's no quorum, you would cancel it at that point. Or if in the instance of the Zoom not working, you'd call to order, you'd say, you make a statement that unfortunately, due to a technological issue, we can't have this meeting because Zoom is not functioning. That's kind of important. So for the boards that do have Zoom capabilities, if it's agendized that it's going to be available to the public via Zoom, and for whatever reason that doesn't happen, either the internet's not working or the equipment's not working or whatever the case may be, you cannot proceed with that meeting if it was agendized that way and it does not work. So you have to cancel the meeting at that point. So anyway, so those are the steps you want to take, and if you ever have any questions, you can always reach out to us. But pretty simple: call to order, and then do a roll call. If there's no quorum, cancel it, or if for whatever reason the Zoom isn't working, cancel it right after you call it. All right, so now we're going to talk a little bit about roles and responsibilities, the board officers and what they do. The chair is ultimately responsible. However, the officers work together and share responsibilities to function within the open meeting. So the chair is responsible for the retention of documents, so that's the agenda, the meeting minutes and the audio. They're responsible for facilitating the board meetings and running them. They review and approve the agenda and the letters of transmittal. They are generally the ones that email correspond with the county manager's office, and they communicate with the BOCC and the county manager's office. The vice chair is the backup to the chair. So if the chair is going to be absent from a meeting, the vice chair would then run the meeting. And you know, if they're out for a long period, they may be the ones that also prepare the agenda and review and communicate with staff on that. They also help facilitate the meeting during the actual board meeting when the chair is present. And then the secretary helps the chair to facilitate the meeting and monitors open meeting law. They draft the agendas and the meeting minutes and can be delegated record retention tasks and responsibility for email. So each board does it a little bit differently depending on the members of the board. But typically it's the chair and the secretary that are communicating those meeting minutes and the agendas to the county staff. Interaction with county manager's office. So the county manager's office is here to assist the citizen advisory boards. Martha, as I mentioned, is the liaison between my office and the different citizen advisory boards. We help provide supplies. So if you have a need for paper or ink or something along those lines for board business, let us know and we can get that within budget. We can facilitate the flow of information between the Board of County Commissioners and the public. So, you know, when you send those letters of transmittal to us, we'll make sure that it gets to the board. To your example earlier, you know, if you do have that letter of transmittal that same night, send it to us. We're in the office in the morning before the Board of County Commissioners meeting. Once the meeting starts, that's a little bit trickier. I'm not checking my emails generally during the meeting. But if you can get us that information before the meeting, we will do our best to make sure that it gets to the Board of County Commissioners. They don't always call that out, by the way, at the meeting, but they do. It is included in their packet. So just because you don't hear the Board of County Commissioners say we received this communication, it's included if you send it. So okay.
We do, we'll send them out that night,
Yeah.
like maybe 10 o'clock, but they'll get to you that night in the meeting.
Yeah. We really try to avoid scheduling meeting, you know, scheduling agenda items such that that it stacks up that way, but sometimes it does happen for one reason or another. Maybe you canceled the previous meeting, maybe the staff got the agenda item to the cab late. I mean, different things happen. So, but we really do our best to try and make sure that doesn't happen. So again, we talked a little bit about this, but we monitor and post publications. I review all of the agendas, and then we retain the notice of meeting, the agendas, the audio minutes. So provide that administrative assistance to the cabs. Try and make it as easy as possible. We realize you guys are volunteer boards. I know that it does take quite a bit of work, and we really appreciate it. And so anything that we can do on our end to make that easier, just let us know and we can do that, within reason. Next slide. So requirements for the board. So we got a question about, or during the break, I got a question about inviting staff members to come and do a presentation. Need to let us know at least 2 weeks before your meeting that you're requesting a staff member. Now, if a staff member's got something else going on, for example, Wednesday nights, depending on the month, there are 3 different cabs same night, same time. So if they're already speaking at another meeting, they may not be available. So you'll have to be a little bit flexible for that. I would recommend that if you know that you're going to want a staff presentation on something, request it well in advance. But 2 weeks is the minimum requirement there. And, you know, really encourage you to to reach out, you know, if there's an issue in your community that you need a staff member, you need, you know. You've got a roads issue and you need to have Dustin come and talk, let us know and we can do that. Or, you know, we can provide you some different directions. If for whatever reason that's not. So the cabs are required to utilize your county email and Google Docs. The Google Docs are really important. That way we can track all of that stuff. We have all of your documentation in there. As you heard from Steve, we're required to keep all of that for a certain amount of time. So that really helps us by making sure that it's in there.
Speaking on that, change this to you, Martha, right, for the editor access on our drives now? Okay. Do that. I can do it right now.
Excellent point. Yes, thank you. And if we need, I'll talk to Martha. We can also have IT help us out with that as well. We talked about submitting the email, this 5 days in advance of the posting requirement, so 8 days before the meeting, 8 working days. We already talked about cancellations, but it's up to the board members to submit that, up to the chair to make sure that happens. Turn in your final minutes to be posted, and then need to be sending your letters of transit. So wanted to include this guy. I actually received an email question about this, about attending the meetings and what the expectation was. So it's not a requirement for the citizen advisory boards to attend the Board of County Commissioners meeting, but if you have items that you want us to be aware of, that you've talked about, that you voted on, it is a good idea to attend. We have a section on our agenda just for advisory board reports. It's for presentation only. But you can let us know what's going on in your community. So, you know, I would ask that, you know, you work with your chair for your individual committee on that, or a cab on that. But I think that is beneficial. So if you're not communicating with us, we don't necessarily have, I mean, I see your agendas, but we don't necessarily know what direction you guys are taking, or you know, items that you want the board to be aware of. This.
When is that meeting?
The Board of County Commissioners meetings are at 9 a.m. on the first and third Thursday of the month.
First and third.
Yeah.
So I guess on that as well, is there also a similar agenda for the planning commission? Because we meet on Mondays and it usually follows that the planning commission meets the day after us. So like we run into that transmittal thing, but for the planning commission.
Yeah, so the planning commission also meets about a month ahead of the Board of County Commissioners. So you're absolutely right. For them, it does end up corresponding. So for the most part, the planning commission is providing a recommendation to the Board of County Commissioners too. There are some items that are where they are the final say on it. And so, you know, if you are providing a recommendation on an item, it's probably better for that recommendation to go to the board that has the final say on it. So this comes up a lot. But, you know, if it's an item that the Board of County Commissioners has the recommendation on, you know, I think the cab should probably just communicate and report that back to the Board of County Commissioners. But if it is a planning item, where the planning commission has the final say, then absolutely. Just a recommendation. I mean, you can provide recommendation to the planning commission. It's just, generally they're making a recommendation themselves, so it's better to.
Was that Thursday, first or third Thursday, was it?
Correct. Yeah. And the planning commission is always the second Tuesday.
And it's a second, at the same time, or?
At 9 a.m. Yeah. Yeah, the citizen advisory boards are really set up to communicate information back to the Board of County Commissioners. However, in the bylaws, it does mention the planning commission, and that is because they do have the final say on some items. Is there a hand? Mandy?
Hi,
Andrew, I do have a question on the reports part of the Board of County Commissioner agenda. Is it, because I listen to a lot of them and I think it's rare that I see an advisory board report out. Are there other things that they would report out other than something that would be on a letter of transmittal or a citizen recommendation or complaint or something? I was trying to get a sense of what an advisory board would report out on. If you could kind of just address that.
Sure. My recommendation would be to stick to items that you guys have voted on and taken action on. Voted to recommend approval or voted to recommend the board do something. That way you're not, because you function as a board, right? So no one member of that board can make a determination on behalf of the board. So I would keep those reports to things that the board has taken action.
Okay, thanks.
It certainly can be, now it can be if a citizen has brought forward a concern in a public comment at your meeting, you certainly can forward that along too. But like I said, I would try and keep the things that you've actually taken.
And would there need to be a transmittal letter that would accompany that? I mean, can something be reported out on where a transmittal letter hasn't been sent?
Yeah, I think so.
Okay. Thanks.
All right. Excellent. This is just going over the Board of County Commissioners. Are you all familiar with the different districts and who your commissioners are? I don't know that I necessarily need to go over this. And then this is some websites that are important that you might want to be aware of. So we've got where you can find the agendas on the Lyon County website, the Citizen Advisory Board ordinances, bylaws and resolutions on the tabs page of the county website. There's chapter 241, which is meetings of state and local agencies. There is, we don't have the link posted up there, but the Nevada Attorney General's office has the open meeting law handbook. And I believe we also have that on our website. And if you ever have any questions or can't find any of that, just let us know and we'll get it to you. And then just a couple of others. I think that's it for this presentation. Are there any other questions before I move on to planning stuff? Yes, sir.
I do, yes. At least at the Dayton Cab location, we don't have the facilities for a presentation to be done and show up on the screen in the room. Because people doing presentations, they might ask, can I bring a PowerPoint? How do I get it on the screen? And I've been thinking that having them present via a connection through Zoom would actually be a good way for them to show materials to the board and to the public.
Well, so you do have the capability of showing a presentation on the same screen that you use for Zoom.
But like taking a thumb drive.
Yeah, so they can't give you a thumb drive, but they can email it to you ahead of time.
Email.
Yeah.
Okay.
Allow the applicant to share screen. So that
Yeah.
Do it that way.
That can work.
If there be a Zoom.
Yeah, if there's a Zoom. So I think not the Dayton Cab might be the only one that has Zoom capabilities currently. Yeah. It is and that's something that we would like to expand at some point in the future, but you have to have the technology, and then it does create some problems, as you know, because we've had to cancel meetings because for whatever reason it doesn't work. Then
And we've had additional IT issues
yeah,
with the computer not recognizing that it has a microphone.
yeah,
And we'd have to substitute a cell phone for the audio.
yeah. So it's not without its challenges. I mean, like I said, we would love to be able to provide that to all the different citizen advisory boards, but it does create a whole nother list of things and considerations. I know. Yep. But we tried to implement it in Smith Valley too, and one of the commissioners had actually donated a TV and all the equipment to do it, but then the internet connection was kind of unstable. So it created some problems there, and then we moved buildings as a whole nother, but.
On the topic of providing materials at the meeting for the public, I've been printing agendas on my own computer at my expense, and it's
Mhm.
typically something like 60 pages.
Uh-huh.
Today we've heard that backup material should also be printed and made available.
Correct.
Is there a way to have the county print what would be a much more extensive amount of printing than that to have at our meetings?
So, the backup material, you have to have one copy of the backup material, and that is a requirement. So we can handle it a couple of different ways. If you are, using your paper and your ink and everything to print it, you can request those supplies from us, for CAB purposes. You have to limit it to that, but we can supply that for you. If it's something that you need, it's a particularly long agenda item or something, we can certainly have it printed at one of our facilities around the county. So you could pick it up at Human Services or something. We can talk to them about that, but you have to pick it up.
Yeah.
So, just communicate with us on that and what your needs are, and then we can go.
Thank you very much.
Another question?
Hi, Andrew, Mandy again. I just had a follow-up question on the transmittal letters and with recommendations. I guess with the exception of one, I never hear it ever reported out what a CAB, if they made a recommendation of approval or denial at either a planning or Board of County Commissioners meeting. Is there a reason for that? Is that not allowed, or?
No, it's allowed. So staff tries to include it in their presentations. I definitely see that often. That is something that we've changed a little bit too, and I've asked staff to include in their presentations. But also, it's kind of up to the board. We do give that information to the board. It's just kind of up to them. There's no requirement that they say, well, the CAB recommended this. And so I've heard commissioners, the chair, say that we've received this letter of transmittal, but I've heard them not to. But it's definitely in their packet.
Okay.
Consideration. Okay. Any other questions on any of that? All right. Are we good? We don't need to take a break before we go on to the next section, do we? Everyone good? All right. Now we're gonna move on to just kind of a quick overview of planning. For those of you that have attended this training in the past, this is going to be review again. I've given this presentation a few times. But just to kind of talk about planning process and master plan, the difference between master plan, zoning, and zoning. Talk a little bit about findings in the public process, and then development requirements that they. So moving on. So talk a little bit about master planning, because this creates quite a bit of confusion among folks, and I do understand it is kind of complicated. So master plan designation provides a framework for future development in Lyon County. So it's what the county wants to be in the future. It's not necessarily what's there currently. Right. Obviously the community is very involved with the master plan process when that happens. We have a ton of public meetings. It usually gets discussed at the CAB and Planning Commission, and the Board of County Commissioners meetings. But it's the vision for how things should look at moving forward. They do not remove or change entitlements. Master plan designation is not the legal, it does not provide legal rights for what you can do with the property. They're advisory in nature. They serve to guide the community at a policy level and to guide future development decisions. Zoning is actually regulatory in nature and generally servicing to implement the master plan and specific permitted uses, allowed densities and development standards. I think it's covered on the next slide. So zoning is a set of laws and regulations that govern how a property can and cannot be used in specific geographic locations. So it's what you have the right to do with your property. So if it's a single family residential 1 acre minimum lot, that's what you have the right to do. Have at least a property that is at least 1 acre in size and have a house on it. That there are a number of other uses that are allowed, but maybe a bad example. But anyway, that's what you have the right to do with that property. So the county cannot change zoning on a property without the permission from the owner. Whereas with a master plan, the community can say, okay, you know, here's what we want to see in the future. Zoning doesn't get changed unless the property owner has requested that. Zoning requests have to zoning and map amendments have to comply with the master plan. So for example, if the community is determined that, you know, in this area, we really want to see low density residential, right? And somebody comes in with a zone change request and they want to see single family lots of 4,500 square feet. You know, just a really extreme example that doesn't comply with the master plan, right? So that zone amendment couldn't be approved. If somebody were to want to do that, they would have to apply for a master plan amendment first, go through that whole process, and then they could apply for a zoning if it got approved. So really want to highlight that distinction. Zoning is what you have the right to do. Master plan is, you know, guiding. It's not regulatory, and so really zoning, the underlying zoning is what we have to go by when we're making decisions and stuff. Next slide, please. So with each different planning application type, there's a set of findings that have to be made. Findings are kind of like a checklist or a requirement, required conditions that have to be met before they can receive approval. So this particular set of findings here that I listed as an example is for a zone change. And so in order for a zone change to be approved, it says that it has to the proposed amendment is consistent with policies embodied in the adopted master plan and the underlying land use designation contained in the land use plan. It also has to say that the proposed amendment will not be inconsistent with adequate public facilities contained in this title, and that the proposed amendment is compatible with actual or master plan adjacent uses. So when the Planning Commission and the Board of County Commissioners is taking a look at a zone change, right? They have to be able to say that those conditions have been met before they can approve it. If those conditions can be met, then they should approve the amendment or whatever the request is. But if the conditions can't be met, then they shouldn't approve it. And so this is really kind of the tool that our different boards use when they're determining whether or not a project should be approved or not. So before the first shovel of dirt can be moved, let's just say for a final, I think I accidentally took a slide or two out of here. This is not making sense. All right, so subdivisions are a topic that come up quite often, that often we get a lot of comment on, and those are items that the citizen advisory boards take up on their agenda. So just to kind of wanted to highlight the process that a subdivision has to go through before it can quote. So before the first shovel of dirt can be moved, a final subdivision map has to be recorded in order to split a large parcel into smaller parcels. There's a whole lot of steps that have to happen before a final map can be recorded. So if it's necessary, if the zoning doesn't meet what they want to do with their project, right? They would have to go for a zone amendment. But if that doesn't meet what what the master plan designation is, they have to start there. So that's kind of the first step. Is to go through the process and go through a master plan amendment if it doesn't meet the requirements of that zoning district that they have already. If the zoning is already correct, then the Board of County Commissioners doesn't see the application before the tentative map. And they don't get a say in the density on the lot because that's what they have the right to do with that property. So we'll go straight to the tentative subdivision map phase. So if the zoning is correct, they can go through that. Now, the tentative subdivision map phase is when a lot of the different conditions get put on a planning item or on that map. So that's where staff takes a look at it. We send it out to different reviewing agencies and let them know what the requirements, what are the required improvements going to have to be in order for that subdivision to comply with law.
Quick question for you. How does one view the master plan for?
Oh, the master plan is on our website. If you go to the planning department, it's on that. And we can, if you need a link or something, just. But yeah, it's got a bunch of different sections in it. Within the master plan, there are land use maps, and that's really kind of what we're going by when we're talking about doesn't meet the intended land use in the master plan.
Okay.
All right. So, and then after the tentative subdivision map has been approved and all of the conditions have been added, the developer then has to meet those conditions before a final subdivision. All that has to happen before the first house can be built. It's kind of a lengthy process. Oh, I think it actually got out of order. I think that's why. All right, that makes more sense. So tentative subdivision map is a map made to show the design of a proposed subdivision and the existing conditions in and around it. The Board of County Commissioners add conditions to the tentative map. So does the Planning Commission and so does staff. The conditions must be based on development standards. They can't be random. We can't put something that's arbitrary on there. So you know, oftentimes we get suggestions, well, you know, the subdivision should be required to do X, Y, and Z. They need to have 6 access roads or whatever the case may be, right? And we can't just put a recommendation on there for that or a requirement on there for that unless there's some legitimate reason for that. There has to be, it has to be based on code. If I already talked a little bit about this, but if the zoning is correct and the development standards can be met through the conditions placed on the map, it's difficult for the Board of County Commissioners to turn down a map. If they meet those findings, if they meet all the requirements, it's pretty tough for them not to approve it. I know this causes a bit of frustration too with the citizen advisory boards because you know, you may make a recommendation of denial or you may hear public get up and say, well, we don't want this new subdivision here. But if it's meeting all the requirements under law and it meets the zoning, then we can't turn it down. There has to be some kind of reason for turning it down. That's where those letters of transmittal with concerns that you guys have sent can be helpful. If you know, if the citizen advisory board says, you know, we recommend denial of this tentative subdivision map because you know, there's some condition that maybe was met or what, you know, we don't feel that this condition is being met and here's why. You know, that's really helpful for us so that we can take a look at that. But if we were to just deny it without any kind of reason, just for the board to say we don't approve of this because we don't like it, well, that could be taking somebody's property rights away and you can get in trouble really quick with that. So we want to make sure that we're providing actual reasons. So this is I'm not gonna run through this, but this is a quick diagram of the public process that a planning item has to go through before it can be approved. This is set out in state statute. And so it's pretty complicated. This is how we get to the number of days that we have to get an item from the time they apply to either approval or denial. State statute will, typically say you have 60 days from the time this application is submitted and deemed complete to the end here. And so that's why specifically with citizen advisory boards, you can't just push it on to the next month, right? Because that would mess up this whole flow. So we have to stick to the timeframes that are laid out in state law. So this is a question that I get often. Why does it always seem like staff is recommending approval for a project? And I touched on it a little bit about, you have to have a reason that if project meets code, that it's hard to deny. Staff has generally been working with that project for months before it gets put on an agenda. A lot of times what happens is we, well before they've even made an application for a planning item, they approach the planning staff and have a roundtable with them. Hey, we're thinking about doing project X, Y, and Z. Can we talk through this? And so staff will set up a meeting with them. We'll go through their project. We'll tell them, look, this isn't going to work. This isn't going to work. This will work, but you're going to have to do X, Y, and Z. Kind of run through that. All that takes place long before any of the boards ever see it. We say no all the time. Staff says no a lot to different projects, probably more than we say yes. I would say, right? Easily. People come forward wanting to do a project that doesn't comply with their zoning, doesn't comply with the master plan, doesn't make any sense. And staff has to say no. I mean, I know we get emails daily about, I would like to do X, Y, and Z with my property. What, and we have to tell them, look, this doesn't work with our regulations. And things like, right, I want to put a commercial business on my residential property that I own, or I want to do, self-storage is one that we get all the time. I want to put self-storage anywhere and everywhere. And RV parks, RV parks are a big one. Multifamily in places where it's not supposed to be. I mean, we get those requests daily. So staff generally, will work through them, we'll see if there's a path forward for them, and we'll let them know, here's the different hoops you're going to have to jump through. Or sometimes the answer really is just, no, this is not going to work for this area. You're going to have to find a different property or a different spot. So we really try and weed all of that stuff out so that the board isn't getting a ton of projects that are just not compatible, not going to work. So if it seems like we're always saying, we recommend approval, it's because we've worked with that property or that project owner, and we've kind of got it to a place where it meets that code and that standard. Companies and developers will rarely file an application if they know that staff is going to recommend denial. It does happen. I think last year or the year before, we had one here in Silver Spring. Somebody wanted to do a solar field, and it didn't meet the requirements. We were like, look, we're going to recommend denial on this. This is not, this doesn't meet our code. Applicant said, we still want to move forward. And so he did. Board recommended denial at the Planning Commission and the Board of County Commissioners, and it didn't get approved. And so, that does happen sometimes, but by the time an item has reached the CAB, Planning Commission, or BOCC, staff has reviewed it a bunch of times, and we've had that conversation. Now, that's not to say though that staff has, catches everything, right? And that's where the public process and the citizen advisory boards are really important. You guys know your communities better than we do, unless we happen to live there, right? And so you're gonna be able to say, well, I'm trying to think of this, somebody wants to put a multifamily on a piece of property, an apartment complex on a piece of property, and it technically meets all the requirements, but maybe there's an access issue that staff hasn't considered, or maybe there's some other circumstance that creates a problem. Those are the types of things that we want to know from the citizen advisory board, so that we're making sure that we capture everything. Maybe it's that can be mitigated somehow, right? Maybe we can put a condition on it that somehow fixes that problem, or maybe it's a deal killer and that project can't move forward. But that's why the citizen, I say that by the time it comes to your boards, we vetted it, but that doesn't mean that it's a rubber stamp. I mean, we really want to know that type of information. Next up, please. So next, I want to talk a little bit about just some of the different development standards and some of the things that we do get questions on, because I get questions all the time about water and water rights. Somebody wants to build a subdivision. Where's the water coming from, right? County doesn't regulate water. That's up to the state. The Division of Water Resources regulates water. They're the ones that issue water rights and water permits, right? And so we can't say, well, there's no water, just look out there, there's no water, right? I mean, if the state engineer says that they've got a water right and they've got permits on all that, then that's not within the county's purview to tell them yes or no. They do it based on hydrogeographic basins, and there's different types of water rights, and so all that stuff gets reviewed and taken into consideration when a project is looked at. Water rights are a property right, so the county can't take them away. We can't say, well, you've got 1,000 acre-feet of water, but we don't think you actually have that. So that's up to the state, right? And how the state handles that. Something that's important to note. Yes.
If the county does see an issue with the water, do they weigh in with the state and say, this is what the county's position is, and kind of lobby the state on behalf of the county? Or do they just?
So we could, I suppose. I don't know that we have in the past on something like this. Water is a complicated deal in Nevada. I will tell you, obviously, so we're talking about water rights and water availability, but obviously when it comes to our utility, right, because we operate in Dayton specifically, the water and wastewater, we're heavily involved with that. But if somebody's going to put in a well to service their industrial facility or whatever, that's really up to the state to regulate. So something I want to point out specifically for subdivisions, every lot that gets created, they have to dedicate a certain amount of water rights. So just because they have the zoning, let's just say somebody has 100-acre parcel and they've got the zoning to break it down into 1-acre parcels. So you could have 100 lots just for simplicity's sake. That's not including roads and everything. But they don't have any water rights. They can't split that lot. That's county code and state law that requires that. And in that case, because it's a large lot, they would have to dedicate 2 acre-feet of water per lot that's created in order to create that lot. And so a lot of that stuff is factored in as a part of that subdivision, not a lot of it. The water piece is factored in as a part of that review for the tentative subdivision. When somebody brings a project forward, they can't move forward unless they have, the state says they have the water to do it. Slide. So projects have to have adequate water and wastewater to serve developments. It's always up to the developer to put in that infrastructure. So if it's going to require a new lift station or it's going to require a line extension or something, the developer has to pay for that. The county doesn't do that. It's our philosophy that development pays for development. And so, again, those are common things that you hear among the public. I know at different meetings, well, who's paying for this? I don't want to be paying for putting in water lines for their project. Well, it's really not how it works. The developer pays for that. They pay for plant expansions through their connection fees, right? And so all of that stuff is factored in. Septic tanks are only allowed if they're not within 400 feet of a sewer line and they meet the minimum lot size requirements. So if you have a well on the same lot, minimum lot size requirement is 1 acre. If you are served by municipal water, it's a ½ acre minimum for a septic tank. There is some, the state can grant some variances on that, but the county's not going to do that. So you know, I just want to point that out. So I know we'll get a lot of questions on that. Same for roads. The developers are required to put in the roads to serve their subdivisions. The county's not going to do that. So we have a road maintenance department. We don't have a road construction department. So any new subdivision, if you hear people saying, well, I don't want to pay for the roads to build the roads in that subdivision, the county's not. The applicant, the developer would be doing that. Now, we generally do, if they build it to our standards, accept those roads for maintenance, and we do maintain them in the future. But in theory, you know, the gas tax that those residents generate brings in money to maintain it. Slide down. And then storm drainage is another thing that we hear about a lot. And so it's somewhat complicated in Nevada, but the amount of runoff created on a site and leaving a property must be the same before and after development. So if you're planning on all rooftops and pavement, right now, obviously that water is not going to seep into the ground as it did before. And so that's where developers have to design different facilities to handle that water, whether it be detention basins or some kind of conveyance channel. The amount of water leaving the property has to be the same before and after, and it's got to be in the same location. So when they're discharging it across property lines, they can't just all of a sudden dump a bunch of water on their neighbor in a different spot. Those are all things that we take a look at, and our engineers take a look at when these types of projects move forward. So that was really kind of I think my presentation, I accidentally did a couple of slides that were important, but or moved around, but that's really kind of my presentation on planning. I'm happy to answer any questions if anybody has any. It's pretty complicated. This is just a really quick overview of the planning process and how that goes, but just designed to answer some of the common questions that we get from citizens and citizen advisors. Any questions? Mandy? You can go ahead and stop.
Yeah, I had a question on master plan amendments. How many are allowed a year? Isn't there a minimum or maximum number or something of how many are allowed per year?
So there's not a minimum or a maximum on the number of master plan amendments themselves, but there's a minimum on how many times a year the Board of County Commissioners can hear them. So it's 3 times a year. We have specific submittal dates for that. So I don't remember exactly which months you're planning master plan amendments, and I'm looking at this. April, August, and December. So if it doesn't fall within that time frame, then we won't hear it.
So they can only hear them 3 times a year, but there could be 10 or 20 amendments. Is that
correct? Yeah.
Oh. All right, and then I had another question back to the subdivision maps. Because we see the tentative maps, and so there's a final subdivision map. How different can that be from a tentative map? So I mean, is that normally vastly different, and is that public information if a member of the public wanted to request to see that final map?
Yeah, so, okay, so two questions. I'm gonna answer your second one first, and that is, yes, they are public information and you can request to see it. The first part of that is that they can't really be different, all right? So at the tentative maps phase, that's when the board is approving the conditions on it. They're approving that layout and everything. If there's going to be changes to that, then the applicant would have to bring that back to the board to receive approval. It's called an amendment of a condition of tentative map. We don't see a whole lot of those. That would go back through the same public process as the tentative map itself. But the final maps are, because it's just a review to make sure that they have met the requirements in that final, in that tentative map that the board had placed on it. It is an administrative process that community development director signs off on. So those do not go to a public process, but they are available to the public if you request.
Okay, thanks.
We are also working on a new GIS platform for our website, where we're gonna be having maps of all the different developments around the county, so that you can see what's been applied for, what's been tentatively approved, what's in process. So, yes, Lisa.
We have tables in the next month or two that will show all development in progress and whether it's what stage of all applications to the county for planning will shortly be on our website.
Yeah, so we're trying to make sure that we're getting that information out, and because I realized, so it used to be that final maps went to the Board of County Commissioners for approval. Then I got the question, well, why are we approving this when all we're doing is making sure that, you know, they've checked the boxes, and so state law allows us to do an ordinance that makes it administrative, and so we did. Any other questions? All right, well, I can give you not too much time back, but about 20 minutes. I really appreciate everyone attending today. I hope this was informational. And if anybody has any questions, you can reach out to Martha or myself or Steve. We'd be happy to answer them for you. Thank you.